from New York each weekday. And if you're watching on the AFA channel, a live shot there of a pretty sunny day in New York, overlooking the Brooklyn Bridge and the Midtown area of Manhattan. We're coming to you from Lower Manhattan, corner of Broadway and Wall Street, literally next door to the Trinity Cemetery where Alexander Hamilton is buried. But AFA Today on the air each weekday, hoping to keep you updated on those things that are important for you to know so that you can take proper action on them throughout the week. The Supreme Court has made a disappointing non-ruling, and by that they have allowed a lower court ruling to stand. And I can't comprehend the, kind of like Obamacare, I can't comprehend the fallacy in the arguments that are being made by those that are trying to appeal it to a higher level. But the Supreme Court on Monday blocked Arizona from being able to enforce a ban on most abortions after 20 weeks of pregnancy. It's the latest blow for states that have tried to enact strict abortion laws. Now, the court declined to hear an appeal from Arizona, leaving in place a prior ruling from the Ninth Circuit, which is the most overturned circuit in the federal judiciary system. The Ninth Circuit U.S. Court of Appeals determined the law was unconstitutional. The Supreme Court decision effectively strikes down the law. Governor Jan Brewer signed it into law in April of 2012. 9 other states have enacted similar bans starting at 20 weeks or even earlier. Several of those bans had previously been placed on hold or struck down by other courts. The latest Supreme Court decision could further embolden opponents of these laws. In its ruling, the Federal Appeals Court said the law violates a woman's constitutionally protected right to terminate a pregnancy before a fetus is able to survive outside the womb. Viability of a fetus is generally considered to start at 24 weeks. Normal pregnancies run almost 40. The Ninth U.S. Circuit Court of Appeals said last year such bans violate a long string of Supreme Court rulings that started with Roe v. Wade in 1973, but supporters of the legislation said the law was meant to protect the mother's health and prevent fetuses from feeling pain. The U.S. District Judge James Teelberg originally ruled it was constitutional, partly because of those concerns. The Ninth Circuit blocked the ban. Lawyers representing Arizona argued that the ban wasn't technically a law, but rather a medical regulation because it allowed for doctors to perform abortions in medical emergencies. Okay, your reaction to this, 888-589-8840. 888-589-8840. Okay, so here's this is a very intriguing idea, specifically in like the 7th or 8th paragraph of the story. Because this is what the Federal Appeals Court said. The Federal Appeals Court said the law violates a woman's... Now watch what they fill into the next blank, okay? The law violates a woman's blank, and this is what it fills in that blank with. A constitutionally protected right to terminate a pregnancy before a fetus is able to survive outside the womb. Now, friends, I got to tell you, I was so puzzled by this story, and that line in particular, and the case that the appeals court, the Ninth Circuit Court, made, that I had to just go look up the Constitution and do a scan of the entire text of the Constitution to find out where the violation of blank, fill in the blank with, a woman's constitutionally protected right to terminate a pregnancy before a fetus is able to survive outside the womb, was in the Constitution. Because I went looking, and it wasn't in the First Amendment, and it wasn't in the Second, and it wasn't in any of them. I couldn't find a place where a woman's constitutionally protected right to terminate a pregnancy before a fetus is able to survive outside the womb existed. I wasn't able to find it. Now, maybe it's there. Supposedly, back in 1973, someone, arguing in the Roe v. Wade case said that, a freedom of choice existed. I haven't seen that embodied in any language either. But really, the Constitution has a, quote, protected right embodied into it that reads, a woman's constitutionally protected right to terminate a pregnancy before a fetus is able to survive outside the womb. Because I didn't think the federal government dealt with anything quite that specific, but specifically in the framework of the Constitution. And it's funny because, and I know some of those of you that are listening right now, you fancy yourself to be Christians, Thinking of Janet, who often comments on the Facebook page. Dedicated listener to AFR. For some reason, doesn't believe most of the stuff that that is talked about on the radio station that she listens to. But it's one of those situations where she I welcome her to do so. Tell me how the Constitution has within it a woman's protected right to terminate a pregnancy before a fetus is able to survive inside the womb. Because that seems pretty burdensome, a pretty big encumbrance to the general, long, far-reaching principles that the Constitution actually does embody. Rights like the state shall create no laws that infringe upon a person's right to the exercise of their religion. Shall not infringe upon the right to own arms and protect them, to bear arms and to protect themselves. See, those are very broad ideas. Freedom of religious speech, freedom of speech, freedom of free religious practice, freedom to protect oneself. Those are big, huge principles. And I consider those rights. I consider those embodied rights. 888-589-8840, 888-589-8840. But I did not know that in the Constitution, and someone look it up for me, because I would still be open to hearing it, that a woman's constitutionally protected right to terminate a pregnancy before a fetus is able to survive outside the womb existed. I wasn't aware of that. I did a Google search on the Constitution. I can't find any of those, very few of those words I can even find, and none of them in that order. So so what's going to happen now is the Supreme Court has rejected this ruling, rejected taking the case. The Ninth Circuit's appeal or ruling cannot be further appealed. So now for the state of Arizona, for the pro-life people of Arizona, for the people that love the unborn in Arizona, they have to go back to the drawing board to try to fix this. But that's not the only news. There is some positive news in that you have a number of these cases that are winding their way through the courts to try to get to the Supreme Court. And if they can, and when they do, one ruling will probably have an overarching impact on all of them across the board. Sometimes the court does reject taking cases because it knows it has an abundance of the same type of case coming at it. And they sometimes just want to get what they consider to be the strongest case heard, the one that has the most far-reaching impact. So, as we're saying this, 888-589-8840, your thoughts on any of this, and what do you think Arizonans should do? 888-589-8840. Let's go to John in Mississippi. John, you're up first with Kevin McCullough. Thanks for being here.
Yes, sir. I just you asked for our thoughts on the matter, and I think that
I did.
Our country has digressed from a republic. I don't think it's quite even a democracy anymore. We have become an oligarchy. We are governed by a privileged few. Whether you vote Democratic or Republic, our representatives don't seem to do what we put them in office to do. And then you've got this governing from the bench, which was never the plan of the forefathers for people who are appointed for a lifetime position on a court to overturn the will of the people. And we see it in state after state after state.
Yeah, it is definitively judicial activism. But I don't think that in this case that the Supreme Court is being particularly activist. You might say the Ninth Circuit was, but the Supreme Court looked at it on the grounds of the need or the burden of the case itself. And my theory on this is, and I could be wrong, John, but we'll see. My theory is the challenge to the Texas law or a couple of other cases that are going to be brought may prove to have a little bit of a bigger, more important reason to address it. And I would suspect that the Supreme Court will take up one of those, even if it rejected this one today.
Well, I hope so, but it bothers me that the Ninth Circuit overturned what the will of the people was. You know, that goes against the roots of what we were founded on when we vote something into law. And, you know, as you clearly pointed out, there's no detailed, specific right like that mentioned anywhere in the Constitution.
Yeah, a woman's constitutionally protected right to terminate a pregnancy before a fetus is able to survive outside the womb, to the best of my knowledge, does not exist in the Constitution.
Well, unless they've changed it in the last 30 days, I would say you were right. Anyway, I appreciate all y'all do.
Thank you, John. Appreciate you.
All right,
thank you so much. Appreciate your call. Let's go to Diana, who's calling from Alabama next. Hi, Diana. Welcome. You're on with Kevin McCullough.
Oh, well, first, thank you for covering this topic, pro-life in general. I just wanted briefly to mention Learned Hand's approach to precedent. Judge Learned Hand. I'm speaking as someone who is not an expert in constitutional law but was interested in youth, so I'm sure I may make some errors. But Judge Learned Hand, many, many years ago, mentioned campaigned against the idea of voluntary bowing to precedent when the precedents are unjust, illegally incorrect. And he was pointing out to other judges and attorneys, liberals hated him for doing it, that the application of precedent in English law is a voluntary matter. And when rulings have been so egregiously wrong, he held that it was every just judge's duty to continue to send up to the higher courts rulings based on logic and correct interpretation of law in the face of their rulings in the opposite direction.
Which I think you're going to see, to be fair, Diana, in this case, I think you're going to see that.
I think so.
I think there's going to be I think there's going to be other cases that come. So I don't think this is the end of the road for being able to ban abortion at a certain week within pregnancy. And I certainly hope it's not, because here's the bottom line. And I have this conversation with people all the time. We have some friends that are with child right now. And the big question is, are you going to find out ahead of time what you're having? Many of them say, no, we're going to wait till 40 weeks, and we're going to see what. But now, I say to them often, you have the opportunity to have like 2 celebrations. See, at 20 weeks, when you get that, when you find out for sure what you're carrying, you can have the, hey, it's a boy or it's a girl party then. And then at 37 to 40, 41, 42, whatever, you have the, hey, it finally came. But some people still want to be surprised at 40 weeks. I think it's easy to determine that 20 weeks is a very fair period of time in the pregnancy to say, we know that this is a child. We know we know which sex it is. We can count the fingers on their hands and we can see the toes on their feet. Anyway, let's go to Oklahoma and speak with Roger next. Roger, you're up next with Kevin McCullough. So glad you're here.
Yes, sir. Am I on?
You are.
Oh, thank you. Yeah, you said what should Arizona do? I think Arizona should go to the Ninth Circuit Court and demand clarification on exactly where in the Constitution that it is protected, and otherwise that they will not
12 miles on Memorial Highway.
Bow to the court or whatever. In other words, they are going to enforce the law that they passed in the state of Arizona.
Well, what would be interesting, and Roger, I thought about something very similar to that earlier today. Thank you for the call. What would be very interesting if that was to occur is what would happen as a result? In other words, would the feds somehow, send police, federal police to Arizona to try to enforce And I'm not sure that they would. I don't know how they would get away with that. 888-589-8840. Let's go to Adam, who's calling from Missouri. Adam, welcome. You're on with Kevin McCullough. Hi.
Hey, thanks for letting me on the show.
Sure
I have a couple comments, and actually just a comment on what you just said. I don't think the feds would send police to it. I think they would do like they always do, and they would cut funding to Arizona completely, like they have in the past when Arizona stood up to do what was right. I think they would just cut their funding completely. But what I think is I think the Supreme Court exists for the purpose of deciding if laws are constitutional or unconstitutional. But abortion is not in the Constitution. It wasn't in the mind of our founders when they, when our country was formed. Somehow, through sin and through different things over the years, we've allowed it into our country. But I've got two children of my own who are wonderful and beautiful, and I love them. And from the very moment, a month in, when we could first see their heartbeat, I knew they were alive. And I don't understand how we can get so excited about finding bacteria on another planet that we can't get so excited about finding a heartbeat in a baby.
That's well said. And thanks for the call, Adam. I appreciate it. A binge thinker for sure. Kevin McCullough with you on AFA Today here on AFR Talk. Glad you're with us each weekday, this same time. Stay with us.